Hi, I'm Anna Denton-Jones, and in the second of the series of Knowledge November videos looking at the topic of subject access requests, in today's session we're going to focus on the extent to which you need to search for data in order to provide a response to the request. So in last week's session we heard that it is possible for somebody to say, I want you to send me all data that you hold on me. And obviously if that's the case and they haven't been more specific, then potentially quite extensive and time-consuming searches are the order of the day. Now, in terms of what data is going to be covered, it's quite a broad group of things that you're going to need to look at. So firstly, there might be physical or manual, as it's called in data protection terms, documents. So a line manager's notebook, for example, could be captured if within that notebook they have made notes about a particular individual. Maybe they've written the individual's name down as a title and a date of the time they had a meeting and then made some notes of that meeting. That could be captured as part of a subject access request. Obviously, it will extend to things like physical personnel files, if those files are a relevant filing system for the purposes of the data protection legislation. And that's all about them being sort of structured and organised. And if you like, there's a temp test. So if a temporary member of staff had to come into your department and cover for you if you weren't there, would they be able to find the information easily? If they can go to a drawer, they can pull out a file that's maybe got somebody's employee name or their employee number or something like that, and within that file information is relatively structured. So for example, they could go to sickness absence records quite easily because there's a divider in that file, then potentially that's captured by the Act. If, on the other hand, you are completely chaotic in your organisation of files and actually it would take a long time to search through to identify what belongs to anyone, then potentially that falls outside of the Act. So think about it in terms of that temp test. It's going to capture email. It will even capture archived emails. So you need to think about that as well. It will capture other databases that you might hold. You might hold people's holiday information or sickness absence, things like that in various databases. They will all be captured. Could extend to phone records, CCTV video if you have that. Obviously any Word documents, filing systems that you might have electronically within your computer systems. All of those sorts of things are potentially going to be captured. Now, in terms of the extent to which you then have to search and look for information, it's clear that the Information Commissioner does expect you to make quite extensive searches. It's not open to you to argue this is going to be time consuming, this is going to cost us time and energy. They really do expect you to just get on with it, basically. There was a case here in Wales which involved the Welsh ministers, where the High Court held that the organisation didn't have to go to disproportionate lengths in terms of doing a search. But it was interesting because in that particular case, if you look at the detail of it, the searching that had been done was very extensive. So every single department had been written to ask whether they held any information about this particular individual. Any data that then came back had been sorted through, it had been given to him. So they had complied with their duties. I think it's clear that the Information Commissioner is not going to let you get away with arguing, that you can't do these things. And the risk is really that the Information Commissioner does get involved and you start getting letters and queries about the extent to which you've dealt with the matter. If anyone's got any questions on that subject, obviously please do send me an email. Thank you very much.